Good afternoon, Mr. Smith.
Good afternoon, Your Honor. I have my client with me in my office.
Okay, Mr. Oughton is present, but I don't have plaintiff's count. Oh, here we go. Just logged in.
Excellent.
Okay, Shannon, you can put us on the record. This is a matter of Oughton versus Johnson et al. Let's see. It's like Mr. Larry Salstrom, Salstrom, for the plaintiff.
Yes.
Mr. Dale Smith for the defendant. Mr. Smith's client is with him, I think he said.
That's correct.
And Mr. Oughton is present in the meeting room also.
Thank you, Judge.
Correct.
Okay, so gentlemen, I'm curious, and one of you may have explained this in your brief, and if you did, I missed it. How is it that Mr. Oughton didn't get included with the 40 or so deeds that were issued by the successor to the platter?
That would be for me to address, Your Honors. Near as I understand it from Attorney Malden, when he sent a letter out back at that time, 2012, he said there was a few lot owners that did not respond. Now, the predecessor, Mr. Kish, went to Florida every winter in the cold weather months, like many people do in Michigan. And it seems to me, looking at those deeds and when they were signed, that maybe a lot of the communication was down, was while Mr. Alton's predecessor was down in Florida. In any event, we have no knowledge, and Mr. Alton was close with Mr. Kish, but there's no knowledge of any letter that came to Mr. Kish, none whatsoever. Now, Mr. Malden said he sent him out to all lot owners. So the only explanation I can come up with was it was in the winter months, or it just got lost in the wash somehow in the mail. I don't know. It's a simple answer, but I'm speculating here from what I do know.
So how did it come about that Mr. Johnson was able to get a conveyance for the land between Mr. Oughton's lot and the lake shore?
That was done by researching through the public records and also having the title company perform research on it. He's been living in the, there's actually two plats, the plat that Mr. Kish owned in, which is plat number 1 of the Whopper Heights, and then there's plat 2 of Whopper Heights, but there's actually a little piece of land between the two of them that is owned by the Van Leuven Trust, and Mr. Johnson is the trustee of that trust, and he was actually living with Mr. Van Leuven for the last few years of his life, and that's why Mr. Johnson went out and pursued purchasing that parcel from Hasho Ltd.
I see. And this land is adjacent then to Mr. Oughton's lake lot.
It's in Wampler's Heights number 2. Mr. Alton's is lot 1 of Wampler's Heights. To the other side is Wampler's Heights number 1. So the lot 1 of my client is adjacent to the plat of Wampler number 2.
If you look, I think we attached the plats, Your Honor, the plat showing where lot 1 and the parcel that Mr. Johnson purchases in front between lot 1 and the lakefront, as was all the other deeds that was referenced in his response. The lot, actually, there's a plat next to it, and the Van Leuven property, he owns property in the plat next to it, but he also owns, there's another parcel of land where he has his home that's actually not included in either plat.
But it's between the two plats?
Not really, I don't think.
A
but-
little bit. I mean, the plat, it sort of surrounds him. There's a public
well,
road that reaches
hold
out so
on,
that he's
Ray.
able to have access to it. But the plat that's not referenced today encompasses all the way around the Van Leuven property. Van Leuven also owns in the other plat also. He owns lots 95 or 90, 96 and 97 in that other plat. And then he owns the unplatted parcel that's not in either plat. And that's adjacent to this property that Mr. Johnson purchased from Hosho Limited.
Does Van Leuven have lakefront in addition to this deed that he was able to get for the land that's in front between Mr. Otten's lot and the lake shore?
That's correct. And it's their contention that they used all that all the way over to the parcel that Mr. Johnson's acquired.
And that's
As
where
this is
we
a CA
disagree.
motion, obviously, those facts aren't there, but there's a dispute over the exclusivity of the use that Mr. Otten and Mr. Kish, or Mr. Otten's claiming on behalf of Mr. Kish, because the Van Leuvens were also using that property and for the same purpose. But yes, Mr. Van Leuven's property also abuts the lakefront. They do have lakefront.
If I may, Your
Okay,
Honor,
so this just expands his claim to additional lake shore, essentially.
That's correct.
All right, I wanted to make sure I understand those. It wasn't really explained very clearly, and it was very curious to me as I was going through this.
There's also a private drive that's shown in the plats that's between the Van Leuven property and the property owned by Mr. Johnson.
Mr. Smith, we lost you.
Okay, I'm sorry. If the court was to look at Wampers Heights #2, which I attached to it, there's a
Let me find
lake. There's
that. This is attached to your brief?
That's correct.
All right, hold on a minute. Let me. Okay. All right. Let's see. One of these was printed. Okay, I'm looking at the plat for #1. Okay, and then I see #2. Give
Okay.
me a moment to get my bearings here.
Yes. And I had those lot numbers wrong for Mr. Van Leuven. It's 95 and 96. If you're looking at it, it'll be down in the far right corner, probably about 2 inches up. You'll see a parcel that's marked accepted.
Yes, I see that.
That's the Van Leuven property. Van Leuven's also owned 95 and 96 in the plat itself. There's that private alley that's in the plat for #2, and then adjacent to that private alley is the parcel that's in dispute.
Okay, thank you. That is very helpful.
if I may, Your
So
Honor,
is there still a private alley that backlot owners have access to and use?
The only ones that have ever used it is the Van Leuvens, and that's a matter that will probably be cleared up in a separate lawsuit.
and the predecessor, Mr. Kish of Mr. Alton has used it, but but we are talking two distinct plats. And the parcel we're claiming adversely is all adjacent to the land in Wampler Heights.
Well, it's actually adjacent to the private alley, is it not?
That would be on the side, but but lot 1, then the land, then Wampler's Lake. The adjacent to the alley, which is a right of use alley, is because I think the lake boundary curves right there, or the land turns. I'm looking for.
I didn't understand that, but hold on just a minute. I'm going to try to marry these two plats together.
And Your Honor, also,
Yeah,
the property that's in dispute is also accepted property from the plat of number one, and that's why it is actually referenced in the deeds, as in Library 600, pages 97 and 98. So that was also accepted from the plats themselves.
All right, I'm gonna run in and get my magnifying glass. I'm looking at Wampler's height number one.
Where is it? Do you want me to get it for you?
Wampler's height.
I'm not sure where it is.
Wampler's height number one is not at issue here. It's part of our argument. Lot one is in Wampler Heights. Wampler Heights number one is on the other side of Wampler's Heights. And
I got you. Well, thank you. I won't waste any more time looking at that plat.
okay,
So is the plat of Wampler's Heights in one of these exhibits?
yes. It's in, well, a portion of it is in defendant's motion attached as exhibit. The first exhibit.
Your Honor, I'm not aware of just a straight Wampler's Heights. There's a Wampler's Heights number one that's spelled out, and then there's a Wampler's Heights number two that uses the numeral. That's what I attached to my exhibits.
Well, I thought his question was Wampler Heights itself, and that's the lots 1 through 10, which are your first exhibit on your brief.
Well, now you've got me thoroughly confused. In which plat is Mr. Otten's property located?
The plat of Wampler's Heights.
Number one.
No, it isn't.
Well, wait a
number
minute.
one. Number one is the one to the opposite side of number two of Wampler's Heights.
All right, hold on just a second, gentlemen. I set this so I would come out on time for 3 o'clock. Sometimes this is in my middle drawer, and sometimes it's sitting on top somewhere. Okay.
Yes, I was looking at his response. My first exhibit has the Wampler Heights subdivision. And then the second page of my exhibit one also has the blown up parcel. That sort of melds the two together. Wampler Heights
All
number
right.
two.
Let me find that.
From Wampler's Heights number one is east of Wampler's Heights. Wampler's Heights number two is west of Wampler Heights. Mr. Alton is lot one in Wampler Heights. Wampler Heights number two.
Your Honor, if you look at the second page of my first exhibit, it shows the lot one that Mr. Otten, the plaintiff owns.
I'm trying to find it.
Okay,
Trying to
sorry.
find it. I was looking in the wrong place. All right.
I did the same, so.
Okay, so I see the plat of Wampler's Heights. And lot 1, okay, I see that. But I did note that the legal description for the plaintiff's parcel is apparently only a part of lot 1. Is that accurate?
That's correct. There's actually a little triangle between the parcel that's owned by Mr. Johnson and lot 1. There's a triangular piece. If you look at the second page again, you'll see that little piece there.
All right, let me look at the second page.
I'm not.
Oh, I see that.
And we
So there's
just,
actually a little piece of parcel of land that goes between lot 1 and the other parcel that's that Mr. Johnson owns.
I'm sorry,
we're saying,
repeat that.
There's
Repeat that,
a little
please.
there's a little triangle of land that was excluded from lot 1. That's also accepted because it wasn't included in the plat itself. And that parcel there is actually between the part that's owned by Mr. Johnson. If you look at the exhibit, Mr. Johnson's that irregular shaped parcel that's got the dots on it.
Right.
And then there's a triangle piece between lot 1 and that parcel. And that one's also accepted out of the plat.
except that,
Wait a minute.
Okay.
Accepted out of the plat or
Apparently it's in the,
accepted?
apparently it's
Let me
in the
finish.
plat. It's in the plat, but accepted from his legal description in the deed.
Okay. So if I follow the meets and bounds description in Mr. Auten's deed, it excludes that triangle.
That's correct.
but what we're claiming adversely is not the triangle. We're claiming the straight rectangle down to the water, the same as what was granted to lot 2 and lot 3 and lot 4 and lot 5, 6, and 7, all the way down.
I understand that. So,
Okay.
so back to the triangle. Who does hold title to the triangle?
That's intended to be part of this suit that needs to be filed concerning the Van Leuven property on 95 and 96. It's a separate suit in Wampler's Heights number 2 plat that would involve all the lot owners. I think Mr. Solstrom just indicated that he's saying it's a rectangular parcel that they're claiming. If that's the case, he's actually claiming property that's in the other plat.
Hold off on that thought. I'm still struggling with the triangle. Is there an independent chain of title that describes this triangle?
Not to our knowledge.
Not to my knowledge. I believe that.
Interesting.
You would have-
The original. Let me. You could speak when I'm done.
Yes.
I'm assuming the very first conveyance out of the plat to whoever was the first recipient in the chain of title included all of lot 1, or did it not?
I don't have the deeds to reflect that, but my understanding is that parcel was not excluded from the site.
Mr.
The
Smith,
description in the
we
deed.
were, so start over again. We missed the first part of what you just said.
My understanding is that parcel was never included in the original conveyance when the rest of lot 1 was sold.
Oh, interesting.
I believe that's correct. Because it ties in with the argument they're making, the reverse argument we're making on adverse possession. See, if you look at the plat of Wampler Heights itself, just the diagram, the land that's gapped between the whole plat and the water is the land that on these other lots was transferred through those quitclaim deeds in 2012, those deeds in 2012.
I understand that.
Okay,
And they're
So I
both,
believe,
and they're all subject to that easement that's still there. They didn't terminate that easement that's there for all the other
Well,
properties.
that's, I realize that's part of the argument, but that's not, what I'm focused on at the moment.
Okay, thank you.
So, yeah, I understood that the bulk of these lot owners got a conveyance from the, hose ho or whatever it's, however it's
Hose ho.
pronounced, of the land lying between their lot and the lake shore. I get that. And I also get that for whatever reason, the plaintiff or his immediate predecessor in title didn't get that conveyance. Instead, Mr. Johnson was able to get it. And that's what brings us here today. And Mr. Johnson does have adjacent land that connects to this deed that he was able to obtain from Hoso. But I mean, is there any theory as to why this triangle was excluded from lot one? It just seems highly unusual that somebody creates a subdivision and then immediately the very first conveyance of a lot in that subdivision conveys something less.
The title company had that same consternation, Your Honor. And I had the same thing when I was reviewing it. It doesn't,
So
happened.
nobody really knows.
That's correct.
except that as part of that,
Yeah, did you go shut my alarm? Apparently I just snoozed it. Okay, well, yeah, apparently there's a lot more questions here that I might have, but I want to move ahead into your arguments today. So we've got Mr. Smith, your motion for summary disposition, and we've got Mr. Salstrom's, your motion to amend the complaint. Let me hear from Mr. Smith first.
Yes, Your Honor. This is a C8 motion based upon the pleadings. We've attached exhibits for the plats and the deeds that convey title from the original platters all the way through to Mr. Johnson. Mr. Johnson is the owner of the parcel that's in dispute. They're claiming that they've always thought they own that property. However, their deed itself, the deed that Mr. Kish received and that Otten is relying on, references an easement across the property that Mr. Johnson is currently owning. That easement gave them permission to use that property to pass and repass. I know their argument is claiming, well, we did more than that. However, you can't turn permissive use into hostile use because the permission to use the property has always been there. So they don't have any basis for doing adverse possession of that property. The other issue that has is it's not exclusive. The Van Leeuwens have been using that property. Also, there's other individuals along there from the lots that have access to it through that easement. So they're lacking in two of the requirements for the hostile and exclusive. Now, they've added in their brief these additional 40 deeds. Those weren't actually included in the pleadings, but I'll reference them now. It's really not relevant because all those deeds are still subject to the easements for everybody to pass and repass that's been in place. And additionally, as he's indicated, if he does win that argument, it started in 2012. That's only 8 years, so he doesn't meet the statutory 15-year requirement under that argument either. So the fact of the matter is he hasn't met his burden of showing that his use was actual, visible, open, notorious, exclusive, continuous, and hostile because he had permission to use it. Others have been using that property, including the Van Leeuwens, and there is clearly an easement. It's in their own deed, so they can't claim that they didn't have knowledge of it because it's referenced Library 600, page 97 and 98, and it's included in one of our exhibits. Clearly shows that they have an easement. Even after, if you dismiss this case, Your Honor, Mr. Otten is still going to have an easement to pass and repass to the lake by that original deed and Library 600, page 97 and 98. Our count 2 was conversion. He conceded that there was no way to convert personal or real properties only for that.
Dismissal.
And then count 3, the prescriptive easement. Once again, there's no doubt that the easement negates any ability to adversely possess or to obtain a prescriptive easement because he had permission to use it. And as far as the
So Mr. Smith, yeah, I understand your argument, and certainly, if the plaintiff were claiming his claim for adverse possession were based solely upon his passing over the property to access the lake, I would think your motion would be very well founded. But he's claiming more than that. He's claiming the ability to maintain a dock at the end of that. There isn't anything in that easement description that gives him a right to maintain a dock, is there?
There is not. Their pleadings themselves indicate that terminated in about the year 2000. From their pleadings and the photos that they showed. The fact of the matter is, it's clearly, we're talking about the ownership of the land itself at this point on the adverse possession claim. I guess as far as the prescriptive easement claim, we don't feel that that's it's still permissive and shouldn't be allowed to expand beyond it as far as the permissive or the prescriptive easement claim. But I think it clearly negates their ability to adverse possess the property. And then their final count was the declaratory judgment, Your Honor. I think Mr. Johnson's in the clear chain of title. These are all recorded documents. It's referenced in the deed itself to the plaintiffs. There's a clear chain all the way through from the Platters to Pantera and Baldwin, from Baldwin and Pantera to Hosho, and from Hosho to Johnson. So the declaratory judgment is just, it's clearly an issue that should be denied also. As far as his motion to amend, I think the clear claim of title indicates that there can't be any slander of title. Mr. Johnson has done nothing wrong to slander that title. He received a deed from the property from the rightful owners of it. So the motion to be amended should also be denied. And we also have acquired title insurance over that property, but obviously the title insurance doesn't cover an adverse possession claim.
So Mr. Sahlstrom, your claims in this case do not assert any claim over the triangle that was excluded from your client's deed, does it?
Sure, that's the whole claim. The claim is that if you go back, Wampler's Heights was first platted in like 1929 or something. It has the strip of land outside of the lot lines. The southerly lot line of lot 1 is adjacent to the southerly lot line of lot 2, same as lot 3 all the way to lot 10. On the other side of that, going up further on the lake, is Wampler Heights number 1. Same thing on the lot lines. It's all got that gap of land. That's the gap of land between the lot and the water. We say that
I'm not talking about the shaded area on this surveyed description. I'm talking about the little triangle that's between lot 1 and that shaded area. My question was, do you have a claim in this lawsuit for adverse possession or prescriptive easement as it pertains to that triangle?
I guess the answer would be yes, because the intent of our claim was to do what's done for those other deeds, and lots 2, 3, and 4 was to take the the parallel lot lines and take them down to the water, the same as was actually memorialized in all those other deeds. That's the land that was used by Mr. Kish for 30 years before there was even the transfer to Mr. Baldwin and Mr. Pantera that led to the transfer to Hose Hole, their corporation.
How does your client get to Mr. Johnson's property, at least the property that's been deeded to him, without crossing that triangular piece of land?
That's not Mr. Johnson's property. That's the private alley.
That's not my question.
Then I don't understand your question. And visually.
Well, are you looking at the sketch of descriptions? I don't have a exhibit label on it that depicts, it's from the Manic Smith Group. It depicts lot 1.
Yeah.
It depicts the shaded area that Mr. Johnson was able to get a deed to. And it depicts a triangle between the two.
Your Honor, it's page 2 of Exhibit 1 for me.
Page 2 of Exhibit 1. There you go.
And just for the record, that triangle piece is not part of the private alley.
I don't have a page 2 to your Exhibit 1. I only have. I simply don't have that.
You don't have this one, Mr. Solstrom?
Yeah, if that's what we're looking at, then I do have that.
That's the one we're looking at.
That's it.
Well, I don't understand. First of all, to back up, we're arguing about moving forward with adverse possession or having it dismissed. So if in fact it's dismissed, it doesn't matter. If it's not dismissed and we have a separate dispute on the boundary of the adverse possession, that's for another hearing. Having said that, I want to come back to your question because I'm not seeing a triangle. The shaded one would be a triangle if extended into the water. Lot
It's
9.
not a triangle. It's clearly not a triangle, but there is a triangle, and it's excluded from your client's legal description. It lies between the shaded area and lot 1. 50 feet in width along the shaded area, 13 point, well, it says recorded 13 feet at the west side, and the other point of the triangle is the southeast corner of lot 1.
Well, we're claiming
you don't see that triangle?
It may be there. I got a magnifying glass on it, but the photocopy may have made it disappear as the copy I got here on his brief. I'm not saying, obviously, if you're seeing something there, it's there, Your Honor. I'm not disputing that. I'm just saying that to the extent it is adjacent to the southerly boundary of lot 1, to that extent, we are claiming the property. Now, if it's here in my eyes with the age and the magnifying glass and the quality of the photocopy don't show it, then I apologize.
No.
Well, if what Mr. Smith is representing, that your client's property excludes that triangle, my question remains, how does your client get to the shaded area if he doesn't own the triangle? Or have a right to traverse the triangle?
Adverse possession. We're
Well,
saying
that may be, that may be, but have have you alleged that in your complaint, or have you alleged that in your proposed amended complaint that you're asking me to approve today, approve the filing of?
The adverse possession we were asking for was the lot 1 extended on parallel lines to the water's edge. So that always included that triangle. It never not included the triangle. See, this is drifting from the focus of we're saying my client's predecessor obtained lot 1 in 1964 by land contract, 1965 by deed. For the next 30 years, he
didn't get lot 1, Mr. Sahlstrom. That's the problem. He got a portion of lot 1. That's the problem. Here's why I'm asking the question, Mr. Sahlstrom. When I have parties in front of me with a property dispute, my goal at the end of that case, whether by dispositive motion or by trial and opinion, is that I'm able to render complete relief. We've got a triangle that strikes me is essential to your client's claim, but you don't have any parties identified that I can see who may have an interest in the triangular piece. I don't know how I can decide this case without deciding all of it.
Well, first, if the triangle is the extension of the alley, well, first of all, let me back up. The plot of Wampler's Height, not number 1, the original, has no triangle. It's got a rectangular parcel. So if there was
that's exactly the problem. But your client and his predecessors in title did not get a deed to lot 1. They got a deed to part of lot 1. Most of it, granted, but only part of it. No record chain of title to that triangle. And if your goal in this case is to establish title by adverse possession to your client's parcel, it strikes me you've got to address that triangle.
It's included in the adverse use for 40 to 50 years. Now, there's 2 questions then. Are you saying the land's not included in our claim, or the predecessor in title, or who should be defendants are not included in the claim?
Well, I guess I'd have to take a closer look at your claim. Hold on a minute. Let me look at your proposed amended complaint.
What we're saying is in Wampler's Heights number 2, Mr. Johnson is a successor to Mr. Van Leuven, who's also passed, or a successor through the trustee. As to the lots 95 and 96, I think 97, they were owned by the Van Leuven Trust, and prior thereto to Mr. Van Leuven. Mr. Johnson is in as 2 categories. As Mr. Johnson, who got the deed in conflict here that we're challenging, and he's named as the successor trustee to Mr. Van Leuven, so that we were intending to capture everybody who's alive that had a predecessor in title and interest. Holzo was a defunct corporation owned by originally Mr. Pantera and Mr. Baldwin. Apparently, Mr. Pantera's out. Mr. Baldwin, like Mr. Van Leuven, died this last summer, but he had a trust the same as Mr. Van Leuven. My client is the successor trustee of that trust. So when we name Mr. Johnson twice as successor trustee and as individually, it is our intent to capture in this lawsuit any living entity, person, or a trust, if call that a living entity, but a legal claim or interest that might have a claim from the predecessors in title to the land we're disputing. I don't know that there is anyone else.
Well, Mr. Sahlstrom, it's clear to me that your complaint doesn't seek to establish title by adverse possession to that triangular piece at the on the lake side of Lot 1. Your complaint, your proposed second amended complaint, assumes that your client owns all of Lot 1. He clearly does not. He owns the portion of Lot 1 that excludes that triangle. There's nothing in your complaint to suggest he's trying to claim that triangle by adverse possession. It simply asserts that he owns all of Lot 1. I don't know.
By metes and bounds, and his claim is to the water's edge from the land he owns. So if I got to rephrase that on an amended complaint, I will. But it is not correct to say that Mr. Kish didn't use that land, all of it, to the water's edge for 40 years, which is what we're alleging.
Mr. Sahlstrom, I'm not questioning that allegation at this stage whatsoever. What I am challenging is you've got your complaint fails to address what claim, if any, your client has to the portion of Lot 1
Well, it's exactly
that is excluded from his legal description.
It is.
You need to fix that.
Then I will on the amendment. But it is also true that Mr. Kish used all of that land for those 30 plus years.
All right. Well, gentlemen, I'm glad I've asked these questions. I think I understand enough to say I'm going to deny the C8 motion as to adverse possession. I think it does indeed involve facts that the court is going to have to get to the bottom of. I don't think a claim of adverse possession or a prescriptive easement to do what Mr. Otten or Mr. Kish and their predecessors have done beyond merely walking back and forth over this property is foreclosed by the fact that they have an easement to walk over and across this property. But what I'm going to do, Mr. Sahlstrom, is grant you leave to file a second amended complaint, but don't file the proposed one that you submitted. I want you to prepare a complaint that addresses this triangle in addition to the other property. If your goal is to establish title all the way to the lakeshore, you need to assert a theory of liability against whoever may be claiming an interest in that triangle, and make sure they're included in a lawsuit. And then we'll figure out where we go from there. Now, Mr. Smith, you had indicated the potential for another claim. Is this what you were referring to, or was there something beyond that?
The private alley is a different dispute. It's triangle's a separate matter altogether.
Is there an allegation? I mean, the private alley is only created on the adjacent subdivision, not on the subdivision in which Lot 1 is located. Is that correct?
That's correct. But just for the record, Your Honor, the way Mr. Sahlstrom has been arguing that he's running parallel from Lot 1 all the way to the water's edge seems to include property in the other plat, though.
I don't think that's what he's alleging. I think he's alleging that his client has a claim by adverse possession to the property that's described in Mr. Johnson's deed.
If that's correct,
Mr. Sahlstrom?
That appears to be so, but I gotta look at the description because until we had this discussion, I wasn't even seeing the triangle. But yes, I think the way you summarized it is correct, Your Honor.
Right, I mean, that's the way I understood it. He wasn't trying to get into the adjacent subdivision or into this private alley. He was simply trying to maintain ownership down to the lake shore, looks like about 25 feet of lake shore.
Well, Your Honor, just so you know, the exhibit study attached to his complaint shows that it goes straight out from the western edge of Lot 1 to the waterfront, which would go across the private alley. And the way that he described it, from just extending the parallel lot lines of Lot 1 to the water's edge, that's the way that I undertook the description in his pleadings and the description that he just gave. If it's just Mr. Johnson's parcel, then he's not going in another plat.
Well, let's do this then. Mr. Sahlstrom, you clarify what your claim is. If it does indeed include a portion of that private alley, make sure that's clearly alleged, and make sure you name all of the parties who potentially have a claim in that private alley.
Yes, Your Honor.
Because if I'm going to grant relief, I want every necessary party here. And it strikes me that the private alley, if your client is claiming part of that private alley, you're going to have to probably name all of the lot owners in, and I can't remember, is this one or two?
This is number 2, but
2, Your Honor.
my belief is I'll look back at it, and you're correct. If I have to do that, then I've got to do that. My memory is that alley was dedicated to the adjacent lots that were all owned by Mr. Van Leuven and Mr. Van Leuven's trust. But I understand what you're saying, Your Honor.
Yeah, you need to make sure either modify your claim so it doesn't include any of that private alley, or if you are going to claim that part of that private alley, you're going to have to name everybody in that subdivision.
I am of the memory that the alley is only within the plat to the use of those lots, but I will check that out because I understand.
Oh, I got you. Yeah. And, I was making an assumption there. It does say private alley. And if there is a dedication in the plat of that private alley to specific lot owners, those would be the only lot owners you would have to name. You wouldn't have to name the rest of the people in the plat. I'll leave that up to your judgment. Yes, I agree with that.
Okay. I understand what you're saying, Your Honor.
So, Mr. Smith, the drawing we've been looking at that has the triangle depicted shows existing cottage. Is that the Johnson cottage?
That's the Van Leuven.
Van Leuven, I'm sorry.
That Mr. Johnson's been living in, correct?
He's the trustee of the Van Leuven Trust. I got you.
Yeah, and he was the caretaker of Mr. Van Leuven.
And is that actually a parcel that was excluded from the subdivision?
It was, as in addition to the other parcels that went in front of the in addition to all the 40 deeds and Mr. Johnson's deed, all that property was excluded from the plats.
Gotcha. Okay, so I am denying the motion for summary disposition. I think there are facts here that I think need to be ferreted out and would preclude a C8 ruling at this stage. I think, as I've indicated, I am granting leave to file a second amended complaint, but I want you to make sure that second amended complaint addresses all of the property and all of the potential owners of that property and includes those owners as additional parties defendant. How much time do you need to do that, Mr. Sahlstrom?
Well, I don't want to have it wrong. So I was going to say 2 weeks. I guess I'll ask for 3, but I think I need 2.
I'll give you 3 weeks. That's fine. Mr. Sahlstrom, you'll prepare an order consistent with my rulings here today?
Yes, Your Honor.
And Your Honor, could we have part of the order? I think he conceded count 2, so that count 2 would be dismissed.
Uh,
The amended
That's the
complaint
conversion claim.
has already got it out, but I'll include that, yes.
Yeah, go ahead and include that so that's clear.
Thank you.
All right, gentlemen, I'm sure I'm going to see you again. It's an interesting case.
Most property cases are, Your Honor. Have a great day.
Thank you.
Likewise. Okay, let's see. Next up is Watts versus Paget. Mr. Marienfeld for the plaintiff, Mr. Andrew Stevens with a V for the defendant, and this is defendant's motion. Gentlemen, I've read your briefs. Tell me what else I need to know to rule on this motion.
Judge, good afternoon, Andrew Stevens. Everything is set forth in the brief. I listened to your prior hearing on the YouTube channel and understand that you've read everything, and we'll ask any questions I can address.
Kind of the same here, Your Honor. Sorry.
All right, as I understand the facts here, the plaintiff slipped and fell in what was likely dirt and or gravel on the sidewalk or on the driveway leading to the sidewalk.
Correct.
And based on weather data that has been referenced, there wasn't any black ice there. There couldn't have been based on the temperatures that existed.
Correct. That's the defense's argument.
And particularly when she got up, she was wet. So if it was cold enough to be black ice, she wouldn't have gotten wet when she fell into it. It would have been frozen. So I don't see how, even though there was some hint of black ice, I just don't see that that's a realistic possibility under the circumstances. It would appear that she slipped in loose gravel, and there isn't anything to suggest that that loose gravel was anything but open and obvious. That being the case, it would appear that the motion is well-founded. Did I get something wrong in my analysis here, Mr. Marienfeld?
Well, Your Honor, I think the case law lays it out pretty good. The duty to a licensee is in regards to a sidewalk, is that with natural accumulations of anything, there's no duty. You don't have to do anything, except when they create a new hazard on the public sidewalk. And in this case, we've got an unnatural accumulation. You see the photographs driving, well, first cement driveway covered by gravel, covered by dirt, and then the tenants pulling into the side yard, forcing dirt, mud, gravel, and everything else onto the sidewalk, caking it on there. I mean, you can look at the photographs. It is permanently caked on there, and it's not to the left of it or to the right of it. It's right in this one area. We would argue that the open and obvious doesn't even apply to this situation because it's an affirmative duty under the natural accumulations doctrine. Now, if it's, whether it's ice, mud, dirt, this is a duty it's separate from an invitee, open and obvious type situation. So I think it gets looked at under the natural accumulations doctrine. We've laid that out completely, and that Michigan is crystal clear. That's what applies to a sidewalk situation. Even if the court thought that this was an open and obvious invitee type situation, this is active negligence of putting this dirt, debris, mud, everything that's on there didn't just come out of the sky. That came from their property onto the public sidewalk. and it's active negligence that constituted that problem. And I think other than that, Your Honor, the last thing I'd put is that it's what she slipped, whether it's ice, whether it's gelled up ice, because it did get 32 degrees that day, whether it's mud or a combination of all that. She did notice moisture on her clothes when she got up. And again, it's nowhere else around on that sidewalk up right there in front of that driveway. So for those reasons, we would ask that the motion be denied unless you have any questions.
Well, your references in your brief to the natural accumulation doctrine really speaks to the accumulation of ice and snow. I mean, how does that bear on the accumulation of dirt and gravel?
Well, it actually, I believe, in the case we cited, Buffa versus Dyke or Dick, D-Y-C-K, page 8 of our brief.
Ron, you're fading out. I think it's probably because you're not speaking into the microphone. Could you say that again?
Yes, on page 8, we cite the case of Buffa versus D-Y-C-K that does talk about taking affirmative steps to alter the condition of the sidewalks itself. And there's cases that reference, and this one referenced specifically ice, but the duty appears to be broader than that as far as accumulations. We've obviously got water involved in there and the mud off the driveway. And I understand what you're saying, that it only got down to 32 degrees that day. Again, there can be ice at that point or a combination of both. And when you've got the mud mixed with the water that's coming out of this driveway, I think mud can be just as slippery as ice, as slippery as oil. And we've got an unnatural accumulation on the sidewalk of something that wasn't there. And you go down the road and there's no other driveways like this than that one. So,
Judge, I can briefly respond. I think it would be unnatural for any dirt or stones to be accumulating on a sidewalk. It doesn't come from nature. It comes from some other act or something putting that on the sidewalk. That doctrine came about prior to Lugo versus Ameritech, where the Supreme Court adopted the open and obvious doctrine. So it needs to be pled in avoidance of open and obvious to show that there was some hidden danger. There was something that couldn't have been found at the time of the slip and fall. And again, this is a condition of land. It's a condition of what was on the sidewalk. There was nobody there throwing rocks on the sidewalk at the time the plaintiff slipped and fell. There's no allegations of active negligence on the defendants.
Well, I don't know what is specifically alleged in the complaint. I didn't look at that, but as I look at the pictures, it seems pretty clear the source of the dirt and gravel that are on this sidewalk and driveway. It's eroding from the defendant's property across the sidewalk and driveway. But your contention is, even if that's the case, if it's open and obvious, that's a complete defense.
Correct. And we're here as licensees, the licensee status, and under the SIT versus Abundant Fellowship case, the defendant only has a duty to warn of hidden dangers or dangers that the licensee would not expect to encounter when they enter the property. Here, the plaintiff testified that when she cut across the street, walked up the driveway, she saw the dirt and some small stones in the area before she turned on the sidewalk.
Well, it certainly appears to me that the open and obvious defense does apply in this situation. And this condition is by anybody's definition, open and obvious. She saw the debris, she walked through it, she slipped. I don't know how a case could be any clearer than that. I am going to grant the motion. Mr. Stevens, you'll submit an order.
Correct, Judge. Thank you. I just want to
Thank you,
say
gentlemen.
thanks to Mr. Marenfeld. I practiced in rural Wisconsin for 2 years, and he was nothing but a gentleman and reminding me of my time there. So
He is,
thanks. Appreciate
he
it.
is a perfect gentleman.
Thanks, guys.
Thank
Good
you.
day.
Have a good day.
Thank you, Judge.